maybe pardon my lord, on criminal appeal, more than 7 years inside custody, filed IA for interim bail, my lord. And another my lord for bail, my lord, more than 7 years.
10 years in jail.
Then 9 years.
Pardon to mention on CRL 151 of 18, custody since 2012, my lord, filing a IM.
2012.
Yes.
Please give.
Okay. Bail for custody since more than 13 years.
Give it.
My lordship, pardon to mention, BLAPL number 10670 of 2022.
BLAPL.
Yes, my lord. It was taken up by your lordship single bench. I'm mentioning it because due to urgency, the other main accused BLAPL 437 of 2021, the order has not been uploaded. So the court below is not inclined to releasing the bail, not releasing the bail in the co-accused. In the order dated was 10/8/2021. The main accused has been
Which order
released
has not been uploaded?
in 437 BLAPL number 437 of 2021, order dated 10/8/2021.
So
This is these matters are connected. Somakant Mandi and State of Odisha.
so what do you want now?
That order may be uploaded so that the learned court below can take the ground and release the
No,
co-accused from
In which application you are mentioning?
in BLAPL number 10670, my lord, of 2022.
Of 2020.
Yes,
What order?
those matters are connected.
That was disposed of
Yes.
in a common order by virtue of a common order.
Yes, common order, not common order, but it has been, your lord has directed that the out of 3 accused person, 2 has been released on bail. So your lord has released the accused person.
So he has to accept just to, why he will verify the other one? If we have already verified and passed the order directing him to be released on bail, he has to just, you have to furnish the bail bond. Why you will verify whether
the learned court below is asking for the order dated 10/8/2021. So the order has not been uploaded in the site.
Order can upload in for the
Yes, madam.
all right. Check it. Get the number. 18. Okay, call one by one. Yes.
Possible item number 18.
My lord, I am appearing in item number 18. I am on VC, my lord. I am pardon.
Why it was kept today?
Today it was kept.
Item number 18, your lordship directed me to serve the copy of the reposition on the state council.
You have
He has not supplied.
Copy is already supplied, my lord. It's a case, my lord. I will kindly request my friend to accept the Xerox copy of the certificate copy, because certificate copy I filed in the court.
He has supplied the type copy only. I refuse to accept it.
Mr. Naik, why you are supplying the type copy, what not the Xerox copy of the
No, Xerox copy of the certificate copy, not type copy, my lord.
No, my lord, no. That is not true.
I have filed in the court. Therefore, I have filed in the court. This is a small thing. Why should I court?
Court file करजन देखी. Mr. Naik का तरफ हुए केस रे किसी deposition copy file लीजिए. Where have you filed, Mr. Naik? It is not filed in court. And why we will ask you to file it, because the trial court record is available with us.
The copy which is available, my lord, this is authentic copy, my lord.
No. You may accept it as authentic copy, but he said that it is a type copy, so he is not accepting the same. He's telling that if you have got difficulty, then there is no problem. We can ask the why don't you give your pen drive so that collect that deposition copy from here. Pass on the pen drive so that it will be given to you, and we can take up this matter next week.
Yes, man. I will ask my junior to collect. Your lordship may pass on.
The Learned Council for the state submitted that since type copy of the deposition furnished to him by the Learned Council for the appellant, he refused to accept the same as Those are not the Xerox copy of the certified copy of the deposition. The Mr. Dharanidhar Naik, senior advocate, submits that he is not having the certified copy of the deposition with him. In view of such submission, let the deposition copies of all the witnesses from the trial court record be supplied to the Land Council for the state pen drive, which will be given by the state council. The matter will be listed on 20th of May 2020. Sorry, 13th of May 2020. Mr. Tripathi,
Yes, ma'am.
just give the pen drive and collect it. Yes.
May I pray, my lord?
Yes.
Item number 25, same problem, and your lordship may pass the same order. Item number 25. Your lordship directed me to solve the copy.
25.
Same order.
Okay, same order in 2025.
I am obliged.
Yes.
Item 31.
Why this case was kept to today, Mr. Misra?
My lord, since the deposition copy which I have
Okay, now you
supplied, two of them are type copies.
okay.
That's all lordship directed to supply the deposition copy to my learned friend, and it
So,
has been. I
Mr.
think it has been
Das,
supplied.
Mr. Das, you have received the deposition. Okay. Yes, you can argue the matter.
My lord. The petitioners, my lord, both the appellants are the appellant number 1.
Okay. How many appellants are there?
2 appellants, my lord.
You have applied for bail for
For
which
2 of them.
appellant? For
For
both
2
of them.
They have been convicted under section 498A, 302 and 34 of the Indian Penal Code.
Come to the operative part of the judgment.
My lord, that operative part of the judgment, lordship may kindly peruse running phase. Running phase 63 it starts. 63 of the brief, internal page of the judgment 53.
Now the relevant part is
64.
64.
Okay.
Accused Govardhan Malik under section 498A, 302, 34. I sentence him to undergo RI for 3 years, pay fine of 2,000. In default of payment of fine, to undergo RI period of 3 months for the offence 498A, and to undergo imprisonment for life and to pay fine of 20,000. In default payment of fine, to undergo further RI for a period of 1 year for the offence under section 302, 34. And also, while convicting the accused Rasmita Malik alias Rasmita Das under section 302, 34 of the IPC, I sentence her to undergo imprisonment for life and to pay fine of 20,000. In default, payment to fine undergo further RI period for 1 year.
So,
And the sentences are concurrent.
Just a minute. This Govardhan Malik, he is appellant number
1.
And this
Rasmita is appellant number 2.
Appellant number 2.
Appellant number 1, Govardhan Malik, is the husband of the deceased.
Husband. And who is this 2?
2 is the Ali's second wife.
What is the name of the deceased?
The name of the deceased is Minna Malik.
Minna,
M-I-N-A.
Minna Malik. When the marriage between this deceased and that Govardhan, appellant number 1, solemnized?
That is in the year 2003. Prior to 12 years of the occurrence. The occurrence took place in the year 2015. Prior to 12 years of that.
Date of occurrence is?
Date of occurrence is 10/12/2015.
Okay. Any issue out of the wedlock?
Yes. 2 daughters, 1 son. And the appellant number 2, who alleged to be the second wife, she was also staying with their family.
Okay.
She has been admitted by the family members as the second wife of the appellant number 1.
Okay. Then what is the cause of death as for
the cause of death is, my lord, due to shock due to hard and blunt trauma. Eyewitness is PW5, son of the deceased.
What is the age of that boy?
That boy is, while she deposed before the court below, his age was, my lord, 6 years.
6 years.
My lord. He is the only eyewitness.
Let us come to that.
My lord.
5 PW.
PW5.
5 deposition.
Govinda Malik.
And you are, both of you are in custody,
My lord,
or you
that
are
I
on
am
bail?
just coming, my lord. Appellant number 1 was arrested on 11/12/2015, and till date he is in custody, never released on
11/12/2015.
15.
And what about appellant number 2?
Appellant number 2 was arrested on 21/11/2000. Appellant 2 was taken to custody on 21/11/2019 from the date of judgment, and during trial she was on bail.
He was on bail. Bail. Then date of judgment is
21/11/2019.
Okay. That means about 4 years and some months.
My lord.
And yes, let us see that evidence.
My lord, PW5. May I?
Yes, of course.
My lord, the relevant part, my lord, para 1. I know the accused Govardhan Malik and Sasmita Das standing in the dock. The accused Govardhan Malik is my father, whereas co-accused Sasmita Das is my stepmother. The deceased Meena Malik was my original mother. One day, my father and stepmother assaulted the back of head of my original mother by means of body in our house. My mother Meena Malik fell down on the ground inside our house by sustaining bleeding injury on the back of her head. Due to assault of my father and stepmother, my original mother Meena Malik succumbed to the injury and died instantly in our house. I had seen my father and stepmother assaulting my original mother. This is the chief. And my lord, in the cross-examination, lordship may kindly peruse. I had seen my father as well as talked with him today. On the relevant day, I was very much present in our house, and none else except my father and stepmother and original mother Meena Malik were present on the relevant time in our house. Prior to the incident, my father and original mother had quarreled with each other, but during quarrel, I was outside of the house. My father was being armed with a body at the relevant time, but my original mother was not holding any instrument or article. I was crying loudly at the time of incident. My grandfather was told me to depose in court. I will not go with my father. I was examined by police in connection with this case in my house. It is a fact that my father and original mother were pushing and pulling each other at the relevant time, and that my father pushed my original mother to the ground, and that my mother did not rise from the ground thereafter.
What about the PM doctor?
That is, doctor is PW 14.
What he has seen?
My lord, on 11/12/2015, I was working as MO in charge CSC Ali. On that day, police requisition, I conducted PM over the dead body of Meena Malik being brought and identified by
One injury is there, lacerated
Yes.
on the left side. What is the cause of death?
Cause of death, that is
Hemorrhagic
due to
shock.
hemorrhagic shock and coma.
Okay. He died at the spot or?
There is no intention to.
And yes, Mr.
Motive part is absent, intention part is absent. The act is also not coming under the purview of 302.
Cannot be sole eyewitness. Sole eyewitness. And they say that chief examination and cross examination totally different. Holding a lathi and but again says that giving push and fell down and see the injury. And so far as number 2 is concerned, absolutely
No allegation
no
against any assault.
And period is also one has remained in custody for
9 years.
2015 means almost 8 years and 5-6 months. The other lady is also 4 years some months. Are the learned counsel for the petitioners, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner number 1, appellant number 1, Govardhan Malik, is the husband of the deceased Minna Malik, and petition number 2, appellant number 2, Rasmita Malik alias Sasmita Das, is the second wife of the petitioner number 1. And the petitioner number 1 is in judicial custody since 11/12/2015, and petitioner number 2 was on bail during trial, and after pronouncement of the judgment on 21/11/2019, she has been taken into judicial custody. It is further submitted that the marriage between the petitioner number 1 and the deceased Mina Malik was solemnized in the year 2003, and they were blessed with 2 daughters and 1 son. And the prosecution case is that the petitioner number 2 was staying with the petition number 1 and the deceased in the house of petition number 1. The learned counsel further submits that PW5 Govinda Malik is the son of the petitioner number 1 and the deceased, who was aged about 6 years, is an eyewitness to the occurrence. And though he has stated in the examination in chief that both the petitioners assaulted on the back of the head of the deceased with a stick in the house, for which the deceased fell down on the ground, sustaining bleeding injury on the back of the head, and ultimately succumbed to the injury and died instantaneously in the house. But in the cross examination, he has stated that the petitioner number 1 and the deceased were pushing and pulling each other during a quarrel at the relevant time, and the petitioner number 1 pushed the deceased to the ground, and thereafter the deceased did not rise from the ground. He has further stated that only the petitioner number 1 was armed with a stick at the relevant point of time. The learned counsel further submits that in view of the statement of the sole eyewitness to the occurrence, there are good chances of success in the appeal, and balance of convenience is in their favor. And since there is no likelihood of the appeal being taken off in the near future for hearing, and paper book has not been prepared, the bail application of the petitioners may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of the doctor PW14, who conducted post-mortem examination and noticed one lacerated wound on the forehead of the deceased, and opined that the cause of death was due to hemorrhagic shock and coma and homicidal in nature. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, period of detention of the petitioners in judicial custody, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioners on bail. Allowed.
Item 32.
Please. Will operative portion of the judgment will
Yes, just a minute.
file.
How many appellants are there, Mr.
My lord, only one
Naik?
appellant.
Sole appellant.
Sole.
Why this matter was kept to today?
My lord, deposition copy on the
Supplied-
last time my lord I have not.
Have you received that? Yes. What is the period of detention of the petition?
Period of detention my lord 7 years, 6 months he was he is in custody since 4/12/2016.
4/12?
2016.
2000. So 7 years, 6 months, no? Okay. Case under section 302.
302.
Life imprisonment.
Life.
And what is the name of the deceased?
My lord, the name of the Veronica Hansda.
Huh?
Veronica Hansda.
B-O-R-E. B-O-R-E.
NICA.
N-I-C-A.
My lord.
Hansda.
Hansda.
H-A-N-S-A.
SDA.
Oh, Hansda.
Hansda.
Date of occurrence?
3/12/2016.
Any eyewitness to the
2 eyewitnesses there.
Who are they?
We told 3 and 4.
Please come to the eyewitness.
My lord, appellant is the daughter-in-law, my lord.
I am placing the
Appellant is the
Daughter-in-law of
Of?
the deceased, my lord.
Acha. Okay. Yes.
we told 3, madam.
My lord, informant Polaus is the elder brother, my lord. He is the my lord, son of the deceased, PW3. I know the accused Elani Hansda standing in the dock, who is the wife of my elder brother. Deceased Veronica Hansda was the Bodoma. Occurrence took place on 3/12/2016 at 6 p.m. At that time, I was present at the house with Suraj Devchand. Suraj my lord, PW4. Devchand, my lord, he has not been examined. And the deceased and the accused. On that day, Devchand had been to our house as a relative. The deceased asked the accused to prepare curry. Suddenly, accused inflicted X blows on the backside of the head and face of the deceased, causing severe bleeding injury. I intervened to save the deceased. Myself and Suraj rushed to outside and informed the matter to another brother, George. George called Polaus to our house. I disclosed before Polaus that Elani had killed the deceased by means of an axe. I have examined by the police in connection with this case. Thereafter, blood cross-examination. There are 3 rooms in our house. We 10 people were residing in the said house.
So not necessary to place anything material. If you have brought it in the cross-examination, just place that line. We are
My
not
lord,
to appreciate the evidence at this stage. Just
here
anything brought out in the cross-examination, which on the face of it will demolish the evidence or just
then,
formal.
Millet, that is nothing, Millet.
So what about then? It is an axe blow on the head and face. Who is the doctor?
Doctor it Millet, PW10.
PW8.
PW8, sorry.
PW8.
PW8. Dr. Sahadev Peraman.
Please come to the evidence of the doctor.
Paragraph 2. The deceased was a lady aged about 50 years, average build with irregularities present in all limbs, dried blood stains found near mouth and nostrils. Face area was splashed with dried blood. Sari and blouse over neck and chest was blood stains. Scalp contained blood stains. There was a laceration on the left side of chin of size to 1 inch. There was laceration of left frontal area above eyebrow size. There was fracture dislocation of multiple teeth inside the mouth and mouth contained clotted bloods. There was a laceration of right parietal area of size 1 inch, mandible wall pounded into multiple pieces. Left frontal bone was multiply fractured. There was multiple fracture of right parietal bone. The membranes of the brain was lacerated over left frontal and right parietal area. There was severe intracerebral hemorrhage. On examination of throat, it was found that the same was intact. Mouth cavity was irregularly lacerated. There was fracture of maxilla and mandible with dislocation of multiple teeth. The stomach was empty, heart chambers empty, uterus was non-pregnant. There were irregular small multiple lacerations in and around mouth. The cause of death was due to brain hemorrhage damaging the vital centers.
So, as it appears, there are three separate injuries.
Right.
One is on the chin, one is on the left frontal eyebrow, the other is one on the right parietal area. Just see that.
Right.
And the effect of those injuries are the fractures and dislocation of the bones, multiple pieces, all these things. So one lady has assaulted another, means mother-in-law. 3 blows by means of axe on the vital part of the body, like head. And the cause of death in paragraph 5 is due to brain hemorrhage, damaging the centers of brain and multiple fractures. So you were in custody, you said, in 2016. What do you say, Mr. Das? Why he assaulted mother-in-law? Any reason has been assigned by
No.
this 2 eyewitnesses on that day? Anything happened for which?
No reason has been assigned.
Just
Quarrel was there.
quarrel, the preparation of curry, it is stated. The deceased asked the accused to prepare curry. ମାନେ curry ତିଆରି କରିବାକୁ କହିଲା, ତାପରେ ରାଗିକିନି ବୋଧେ ହଠାତ୍ ଦେଇଛି।
Because the P4 is more elaborate.
କଣ କହୁଛି P4?
On the occurrence took place on 3/12/2016 at 6 p.m. Ilani, Orenika, and Ritesh and Devchan and myself were present in our house. Devchan had been to our house on that day as a relative. My grandmother Borenika asked Ilani to prepare dinner for him. Accused refused to prepare dinner. A quarrel erupted between them. In anger, Ilani inflicted axe blow at the backside of head, near the ear and front side of the face of Borenika. When we intervened, accused also chased us to kill. In fear, we ran away and informed the matter to George. He then went to inform the matter to my father. My father then informed the matter at the PS. On arrival of my father at my house, I disclosed everything about the occurrence before him. I had been examined by the police.
Now, this lady has remained in for 7 years and 6 months. This and it's an appeal of the year 2020, and any issue out of this petitioner? No issue. Or the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is a lady who is in judicial custody since 4/12/2016, and she's aged about 27 years. She's having a girl child who is now staying with her mother-in-law, with her mother. Occurrence in question took place on 3/12/2016, and PW3 and PW4 are the two eyewitnesses to the occurrence. And their evidence would show that the occurrence happened all on a sudden when the deceased Berenika Hansda asked the appellant to prepare curry. Deceased Berenika Hansda, who is the mother-in-law of the appellant, asked her to prepare the curry. And it is stated that during course of such quarrel, some axe blows were given by the petitioner. The land council further submits that there is no chance of early hearing of the appeal in the near future, and in view of the period of detention of the petitioner in judicial custody, and particularly the proviso to section 437(1) CRPC and the surrounding circumstances under which the offense alleged to have been committed, the bail application may be favorably considered. Stop. Learned counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW 3, 4. So also, the doctor PW 8 conducted post-mortem examination and opined the cause of death to be due to brain hemorrhage damaging the vital centers of the brain and multiple fractures. After considering the submission made by the learned counsel for the respective parties, nature of evidence adduced, surrounding circumstances under which the offense alleged to have been committed, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, and taking into account the proviso to section 437(1) CRPC, we are inclined to release the petitioner on bail allowed. Please. To which she refused, and then a quarrel ensued, and during course of the quarrel, she is stated to have assaulted. You the Koilani be prepared for the state art. So please. Asha, there is an application or no? Is it? There is an application for stay of realization of fine. That also we are trying. Stay realization of fine. Yeah.
Item 33.
33. 33. Why it was skipped today?
Deposition.
What is the council? Shamananda Jinnah. He was present on the other day. So ଜାଣିଥିବେ ତ ନିଶ୍ଚୟ ଆଜିକି ରହିଲା ବୋଲି weekly program. ଆମେ ସେଦିନ କହିଥିଲୁ ଯେ weekly list ରୁ take up ହବ ବୋଲି. So next week କରିବା. Right. Non appears for the appellant put of this matter. 13, 5/20/24. Yeah.
Item 34. Item 35.
May I please? My lord, this case posted today for hearing on the bail application, as I have not sought the deposition. On that day, I have sought the deposition.
Mr. Tripathi? Yes, ma'am. You have received. So what
So,
is the conviction? And what is
Conviction
the
302, 498, 304B, 302 of
Please
the
come to that part.
41,
Case
41, page 41, paragraph 18, second para. Accordingly, this court sentenced the convict Pramod Gowda to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 only in default to undergo further rigorous imprisonment for a further period of 1 year for the offence under section 302 IPC, and no separate sentence need to be imposed under sections 1 and 4 of DP Act as per ratio of honorable acts.
So 498A, 304B, 302 IPC, Section 4 DPR.
DP Act.
You are found guilty. And you are the husband.
My lord, I am the husband.
Okay. What is the name of the deceased?
Sasmita Gowda.
When the marriage was solemnized?
18/4/14.
And date of occurrence?
23/8/14.
Oh, within 4 months.
My
Cause of death?
burn injury, my lord.
She died on the very day or survived for some days? And
Dying declaration was recorded thereafter
okay. DD recorded by whom?
by magistrate, my lord.
Who is PW?
PW 16. PW 18.
Please come to that evidence of PW 18.
My lord, petitioner in custody since 15/9/14, my lord. He has also received burn injury and remain in custody.
15/9/14. 2014.
Burn injury remain in in medical, my lord, for about 20 days. 18, my lord.
कौन कहला आपनकर DD रे? Okay, that has been recorded as exhibit number 13. 13/2. 13 exhibit 13.
On 24/8/14, I was working as additional Tahsildar.
No, we just take 13 देख लो. ये तो कुछ कहूँ ना आंटी कौन कहले बे. खाली recording को. हाँ. Right. हाँ. Have you got that dying declaration with you?
No, ma'am.
Hey, the Bharkari copy state council को दियो तो. Got a 13 is our mark page. We are providing it to you, both of you. Just data copy कर दियो. पढ़िले?
तुमरो नाम कौन? मोर नाम सस्मिता गौड़. तुमरो स्वामी को नाम? मोर स्वामी को नाम प्रमोद गौड़. तुमरो
माइक एडजस्ट करो दुटी.
तुमरो बयस केते? मोर बयस 19 वर्ष. तुमरो ग्रामर नाम और ठिकाना? मोर ग्रामर नाम अंकुशपुर, पोस्ट अंकुशपुर, थाना ब्रह्मपुर, जिला गंजाम. प्रश्न, घटनाटी केतेबेले और केउ दिन हैला? उत्तर, घटनाटी शनिवार रात्र 11 घटिला. प्रश्न, घटनाटी किपरि घटिला? ए घटना मोर स्वामी सहित खंड हेबारु घटिला.
गंडगोल हेबारु गोळटा छाड़ देई जंदी. हां.
प्रश्न, ए घटनाटी किपरि हैला? मोर स्वामी केरोसिन ढाली निया लगाई देले परे पानी ढालिला. प्रश्न, पोड़ी घटनाटी किए किए घटाइले? पोड़ी घटनाटी मोर स्वामी एकुटिया घटाइले. प्रश्न ए घटना रे किए दायी थिबा कहूच ए घटना मोर स्वामी सासू दायी अछंती घटना कोन
So, what do you say?
What is the extent of burn injury?
90 to
90 to 95.
95
Brita pore achi eta
that is my lot
PM report
Doctor-
second page re
90.
hard
90.
line 3 to
20
4.
to 19
Approximately 90% of the body surface in So one magistrate has recorded the dying declaration and she has stated how she sustained burn injury. You are in custody for
above 9 years
9 years and
2-3 months
this is 5 and they are 3. So 8 months. Any and
all the independent witnesses declare hostile here
independent witness कौन करेगा घर भीतर घटना है independent
Well-
witness कौन करे ଆଉ କିଛି तो ये 2023 ର appeal ना
my lord it is their criminal bill 2023 my lord.
7 ବର୍ଷ ଆହୁରି So we are adjourning this matter. Let you complete first 10 years. We'll see. And by the way, you obtain the criminal antecedent. Maybe that's
Who shifted the victim to the hospital?
The one auto driver shifted the victim and the present appellant. Appellant also remain in my lord medical for about 23 days because of the burn injury. That
He
is that.
also
My
sustained
lord,
burn.
sustained injury and thereafter arrested from the medical on 15.
maybe some kind of tussles were
My
there
lord,
during
tussle
that.
Was it
during that.
under coroner? Suddenly,
Um,
it will be there at least completely 10 years.
Okay. The Learning Council for the petitioner submitted that the petitioner is in judicial custody since 15/9/2014. Let the Learning Council for the state obtain the custody certificate. So also criminal antecedent if any against the petitioner. Put up this matter in the month of July for the
Item 38.
କୋଉ ଜେଲରେ ଅଛି ଜାଣିଲେ ତ ଏଇଟା କୋଉ ଜେଲରେ ଅଛି ବୋଲି
ବରହମପୁର ଇଏଟା ଅଛି ତ
ଅଛି ତ
ହଁ।
ହଁ
Circle jail forum.
And also with regard to conduct of the appellant.
With regard to the conduct of the appellant during the period of yes, from the jail superintendent. Any other matter? 38. Council.
38 रे से last time जो jail रो आस्था prisoner engaged Biswajit Tripathi. He is not there today. Inform he is in VC, madam.
I'm in the VC. May I please, your lord?
No, the client is there.
No, client is not there.
No, he found me wrong.
ସେଟା prisoner petition ଗୋଟେ ଆସିଥିଲା ବିଶ୍ୱଜିତ ତ୍ରିପାଠୀକୁ engage କରିବା ପାଇଁ ତ ବିଶ୍ୱଜିତ ତ୍ରିପାଠୀ ସେଦିନ ନଥିଲେ. Might have directed me to inform him.
Okay.
So I informed he appeared today.
Yes, Mr. Tripathi.
My lord, I don't have also any instruction with regard to appear in this matter, my lord.
You have not filed a VNAM also.
My lord.
Your name has been reflected because so VNAMA is to be filed then otherwise how can you argue the matter?
He is telling that he has also no instruction from the petitioner.
He can take
Nobody has contacted me.
No, କାହାଠୁ ଶୁଣିଥିବେ ଆପଣଙ୍କ ନାଁ କହିଦେଇଥିବେ ଲେଖି ପଠେଇ ଦେଇଥିବେ. So why not that
you can connect to the
concerned jail and ask the jail superintendent if he wants to engage, just send the VNAMA to the
we can take it up. So the first item. So
launch pare we can take up this as first item. He is now in which jail? He's a sub jail Bhubaneswar ଅଛି. So
special
connect कर दियंतु आपण मिस्टर दास भुवनेश्वर अछि 2023 रो अक्टोबर मासरे भुवनेश्वर थिला जो प्रिजनर पिटिशन दा लेखिछि कनेक्ट कर देन तम पचार दबा देन
One thing, my lord,
His name is Vishwaranjan.
Biswajit Tripathi as per the prisoner's petition.
Mr. Tripathi? Your full name is Vishwaranjan or Biswajit?
Biswajit Ranjan Tripathi.
Acha, is it the mobile number your is 9040 694
No, my lord. No, my lord. No.
Then you contact with this phone. He has collected the phone number. You just give ring to this number and ascertain whether any other party is there. I'm going to buji kuhuntu. I'm just so that 10 number to note korantu. 9040 694 100. Hello? Ita na lekhijanti Biswajit Tripathi. Hello? See that?
Do I require to appear in the?
No, you are not required because this is not your phone number.
Mr.
Das must contact in this phone number and ascertain.
Obliged.
So after you get the, you can ask, we can take up this matter. Let us say after lunch because now that death reference will come in. So it will be taken up after lunch that you will matter. Huh?
That phone number.
You know him?
No.
For that caller ID ru bhat kale. Je koti kar advocate kon achi se. Bhubaneswar ହେଇଥିବ kon ହେଇଥିବ. Just give a ring to him and ascertain. Yes.
Item 2.
Item 38, I informed the advocate, concerned advocate, Vishwajit Tripathi, my lord. He is now gone to Keonjhar. He told that he will file the Oklatnama. He has the information that he will file the Oklatnama.
कितने नंबर सुना
38.
ना ठीक है तो
हाँ।
item 38 लिखते हैं JCRL number 57 of 2023 prisoner's petition has been filed at flag A for engagement of advocate Vishwajit Tripathi. The land council has not appeared. However, we requested Mr. Orupananda Das an additional government report to contact Mr. Vishwajit Tripathi in his phone number, which was given in the prisoner's petition. Accordingly, after contacting Mr. Tripathi, it was told to us, it was informed to us that he has agreed to file the Vinama for the appellant by next week. Put of this matter after ensuing summer vacation. Yes, Mr. Panda. These witnesses to the last scene, my lords. ଆପଣ କୁଆଡେ ଗଲେ ଆଉ ନଥିଲେ କଣ ଆପଣ
My lordship, I am appearing through VC, my lordship, and
Ah.
also submit the note, my lordship.
ଯୋଉମାନେ ଥିଲେ ଯଦି ବେଲ୍ ହେଇଛି ସମସ୍ତଙ୍କର
My lordship.
ଆପଣ ଯଦି ଭିସି ରେ ଥାନ୍ତେ ତ
I am
କଣ
appearing through VC.
କଟିଲା
ହଁ
ବିଷୟ ଥିଲେ କଟିଲା so that audible ହେଲାନି
ହଁ ସେଟା ପୁଣି କେବେକୁ ରହିଲା କେବେ
Nahi, my lord, this my lord.
ସେଟା ନେଇ ଆସ ଆର ସପ୍ତାହକୁ ନେଇ ଆସ
My lordship,
ତାର
if
matter.
possible, my lordship, kindly list the matter tomorrow,
No,
my
no.
lordship. It is pending in weekly list, my lordship.
It's all right. ଆପଣ କହିଦେବେ ତ ଅନ୍ୟମାନେ ବେଲ୍ ହେଇଛି ଯଦି ସେମ୍ ଫୁଟିଂ ରେ ଥିବେ ଦେଖିବା ୱିଲ୍ କନସିଡର
My lord,
Monday.
similar footing, my lordship.